So let me, speaking of the beginnings of this administration, the Trump people came in with the idea that there were a number of decisions, I guess would be the best way to put it, that the Obama administration had put in place, regulations that they wanted to get rid of. And Congress only had about a 60-day window to do that. And I guess it's about to expire. Paul Larkin is our guest right now. He's a senior legal research fellow at the Meese Center for Legal and Judicial Studies at the Heritage Foundation. Paul, thanks for your time.
My pleasure.
So they've been fairly effective in this past 60 days using this review power to roll back some Obama regulations, correct?
Correct. I think it's 14 is the number they've been able to roll back.
That is more than I thought. Now, did they have to go through the House to do that?
Yes, they've had to go through the House and the Senate. Each one has to pass the same joint resolution of disapproval, and then they have to send it to the president for his signature in order for it to actually take effect. So
what are some examples of some of the regulations they've rolled back? Was it the ones on I know he's had them review offshore drilling and some other executive orders. Are those the kinds of things that have been rolled back, or were there other things that maybe the public wasn't as familiar with?
Oh, there are others. After all, there are several ways the president can go about cutting back regulations. The Congressional Review Act is just one. He can order the agencies to reconsider a rule, and then they have a certain amount of time to do it, or they can try to address this in the appropriations process. So there are a variety of them out there. Probably most people don't know about too many of them.
Yeah, that's true.
But each one of them would have a dampening effect on the economy.
Okay. I mean, can you give me an example maybe of one they did roll back?
Sure. They rolled back a rule that would have allowed municipal, county, and city personnel who are dealing with pension plans to borrow from private pension plans to make up for shortfalls in public pension plans.
Yeah, that sounds like something that was written in there to help Chicago.
Well, Chicago probably, but there probably bet you there are others out there too.
Yeah, I'm sure there were a few others. So that's an example of things that they reversed. But technically, the window to do that, and you said there were 14 of them, expires tonight at midnight. Is that correct?
It's actually incorrect.
Oh, okay. Sorry.
And let me explain why. The Congressional Review Act gives Congress 60 legislative days in order to review and nullify a rule. Now, we went from one Congress to another, so that adds a certain time period into it. But you have to keep in mind, the opening part of the Act says before a rule can take effect, it has to be submitted to Congress by the agency. That means if they don't submit a rule, it is not yet in effect.
True.
And the time period for Congress to consider that rule hasn't started to run. So if there are rules that were submitted by the Obama administration, by the Bush Jr. administration, or by the Clinton administration that they didn't submit to Congress, those rules can still be nullified today.
Wow. Is this something that somebody's working on actively, or is this just something you've noticed in this law that's sort of a loophole?
Well, I wouldn't say it's a loophole. Keep in mind, the purpose of the statute was to give Congress the opportunity to nullify a rule before it took effect, if it thought the rule was unwise. So if you never submit the rule to Congress, it doesn't have the opportunity to review it and eliminate it. So you have to submit it in order for Congress to get that opportunity. So it's not a loophole. It's actually a requirement imposed on the agency. And if they act unlawfully, the rule is not supposed to have any effect.
Wow. Is there anybody whose job would it be to go back and find out what's still sitting out there that might be able to be reviewed?
Well, there are ways of insourcing it and outsourcing it, so to speak.
Okay.
I mean, the administration could order every agency to identify every rule that it has promulgated over the last 4 years, 5 years, however far back they want to go, and also identify the date it was sent to Congress. Well, any rule that was promulgated that the agency didn't send to Congress is a rule eligibly nullified. So that's how you would do it, by insourcing it. But you can also outsource it. You'll have various businesses, law firms, public interest organizations can try to find out if rules were never submitted to Congress, and those rules that were never submitted can be nullified.
Wow.
And there's a website, redtaperollback.com, established by the Pacific Legal Foundation, and Heritage is a co-sponsor, in which they're encouraging people to identify rules that were never actually submitted to Congress.
Well, I hope they do. I hope obviously somebody's working on it. So there may be an opportunity there when we talk about rolling back red tape and regulations, an open window, so to speak. That's a good thing. I'm glad to hear it.
Absolutely. I mean, the administration is committed to eliminating rules that impose an unreasonable burden on economic growth. And if there are rules out there that do that, they would like to know about it so that they can be eliminated under this act.
Very good. Since I've got you on the phone, and I know it's not the subject that we plan to talk about today, I wondered if I could ask you a question about Director Comey's recent testimony to the Senate.
Well, I'd be glad to answer if I knew, but the truth be known, I didn't pay attention to his recent testimony, so I don't think I'm the person to go to.
Okay, I had a question that had come up because people have gone back and questioned whether or not he overstated the number of classified emails that had been sent from Huma Abedin to her husband's laptop, and my question was whether or not intent is part of that law. If you send out classified information, my understanding is that intent is not part of the law that governs classified information.
That is my understanding, but I haven't looked at the statute. But I've been told by other people that if you are negligent or reckless in how you handle classified information, you can violate the statute.
Very good. That's kind of it's what I thought, but I wanted to ask a legal expert while I had you on the phone. Listen, Paul Larkin with the Heritage Foundation, I appreciate your time. People can go read more of your thoughts on this subject and many more at heritage.org. Thank you.
Oh, it's my pleasure.
Yeah, have a great day. Appreciate that. Hate to get a good legal mind on the radio and not ask him a question if I've got it lingering in the back of my mind. So I don't know if you missed this or not. But yesterday, the big story today in all of the newspapers is that